on the 8:30 hearing. Do we have a court order?
Yes, ma'am.
Okay, wonderful. Good morning, everyone. On the 8:30 hearing, Oxidine versus Ramirez. Let me ask counsel, do you happen to have any witnesses?
Yes, Judge, I have Mr. Oxendine.
We don't do evidentiary hearings at 8:30. We don't have time.
Well,
We got a courtroom full of people.
I understand. It wasn't going to be a tremendous amount of time. I don't need much arguing, Judge.
It was only for 15 minutes. How are you going to do direct examination, cross-examination, and redirect examination in 15 minutes? You guys can come back at 10:30.
Okay.
Okay, I'm so sorry. Michelle, this never should have been said at 8:30. You guys know better to set an evidentiary hearing in 15 minutes.
I just think it's going to be really quick. There's no opposing counsel, but that's
But
fine.
that's not fair. But he still gets a chance just because he's first.
I understand. I knew it was going to be, mine was going to be a quick, Judge. I thought we could do it.
It's not fair to the other side.
I understand. That's fine.
All right.
We can wait.
Okay, thank you so much. Let me please go ahead and do Bank of New York Mellon versus Martinez, please. Defendant's motion to set aside clerk's result. All right. Good morning. Good morning. This is Bank of New York Mellon versus Martinez. Defendant's motion set aside clerk's result. We have a court order. Counsel, please state your defense direction.
I'm Andrew Wyman. I'm for the Martinez defendants. We're the movements.
Good morning, Your Honor. Iraj, E-R-A-J-H, Pandit Ratna, P-A-N-D-I-T-A-R-A-T-N-E, on behalf of the plaintiff.
Wonderful.
Judge, did you receive a copy of our opposition?
I did. That's fine. Let's go ahead and proceed, please, with the motion.
Thank you. Also present for the record is my client, Joseph Martinez.
Okay, wonderful. Thank you.
This is plaintiff's motion to set aside a clerk's default. You're, I'm sure, familiar with the standards. We set it forth in our motion, and we need to establish that the failure to file a response to pleading was the result of excusable neglect, that we have a meritorious defense, and that we were reasonably diligent in setting aside the default. And because we're dealing with a clerk's default and not a default judgment, those standards are a little more lenient in our favor. We've filed, with our motion, a proposed verified answer, and we filed also an affidavit of Joseph Martinez. And,
I saw that, yes.
Okay, correct. So we've set forth in sworn fashion, regarding excusable neglect, we've set forth in sworn fashion with Mr. Martinez's affidavit his mistake in not timely responding to the complaint,
Correct.
but that when he received it, he did immediately contact the servicer who he had been in loan modification talks with for upwards of 2 years at that point.
Correct.
We've set forth in that motion his belief that his response was not required, and that belief was based upon conversations he had had with 2 different servicing agents who had represented to him that he could disregard any concern over foreclosure.
Let me ask plaintiff's counsel, we always try cases on the merits. Why not set this aside? It seems like it's a valid excusable neglect. It was timely.
Judge, I don't feel like it's a valid excusable neglect. Nowhere in here did Mr. Martinez say, I did not file it, because once you're served with the complaint, it's the paperwork from that.
Yeah, but he was told. These are based on representations.
Judge, I don't believe he was told not to file an answer. There's nothing in this affidavit that says I was told not to file an
He was
answer.
told not to do anything. Right? That's in the affidavit.
It says I was under the impression that while in the midst of a loan modification, no foreclosure proceedings were to take place.
It's based upon the representations from the other side. Right?
And those representations are in the affidavit.
Yeah.
Disregard any
upon-
concern.
But Judge, that again, that's its hearsay, and
Motion's granted.
Thank you.
Thank you. One other thing, this is on the trial calendar for May. Now that our motion is granted, the answer will be filed as of today.
Absolutely.
That keeps us, I was about to say that makes us technically not an issue,
Not a
correct?
problem, then it'll be separate trial again.
It'll be what?
Separate trial again. Right?
Okay, thank you very much.
thank you, Your Honor.
All right, let me go ahead and do, please, Homeland Property versus Minicus. Everybody ready? All right, good morning. We have court order on Minicus. Oh, wonderful, thank you. Good morning, nice to see everyone this morning. We're here at Homeland versus Minicus. Good morning, very nice to see everyone this morning. If we could please have appearances on the record from all
Sure.
counsel.
Spencer Sachs on behalf of the Plaintiff Homeland Homeowners Association.
All right, this is defendant's motion to cancel. Oh, I'm so sorry, go ahead.
Peter Sigden and John Basson on behalf of the Medics.
Wonderful, very nice to see everyone. This is defendant's motion to cancel and stay pending appeal. And I read your motion, you may proceed when you're ready.
Well, first of all, Your Honor, we paid now into court the $84,000, whatever, the 75 plus 2 years interest.
And we're fine with the cancellation of the sale.
Perfect, so that's for that record, I'm going to do that by agreement, that's perfectly fine.
Okay, and then that leaves the question of a stay on the rest of the case. I mean, we do have a...
You have legitimate good faith belief and appeal, and
Yes.
I've read your motion. Let me hear a response, please.
Sure. Well, the first prong of the test to determine whether or not a stay should be granted is whether there's a significant likelihood of success
On the merits.
on the merits on the
Correct.
appeal. And they haven't even alleged that in the motion, let alone made any assertion or any proof of that.
Okay.
In addition, these
Do you
are the
want me
issues.
to ask them to refile that and put that in the motion? Is that what you're asking for?
Well, I mean, they're not even making a case for
Okay.
that, so I mean, that's what the case law says. Okay, so number two is, the settlement agreement was entered into 5 years ago. Your Honor entered the summary judgment and a final judgment enforcing a settlement agreement. So they already got a 5-year stay of not doing what they were obligated to do under the settlement agreement. There's things under here that are not even monetary. Under the injunction, they're not supposed to advertise to have a stable. They're supposed to use the same vendors for all the horses there. They're supposed to submit plans to the Architectural Review Board.
Okay.
They're supposed to do lots of things, because we have a fee hearing that we're trying to schedule on our motion for fees and costs.
Okay.
So this omnibus stay over whatever has to happen in the case, we don't think is appropriate. They haven't met their burden in order to get that. There's also the issue of what's going on in the appellate court. There's a show cause order in the appellate court because there needs to be some housekeeping done here where they need us to drop count 2 for specific performance, because the summary judgment didn't deal with it.
Okay.
And that's why the 4th is kind of held up on that issue, and I've already agreed to drop that.
Got it. Okay.
So I think they're trying to relinquish jurisdiction from the 4th District to come back here
Okay.
to enter an order dismissing
Well,
those.
should we at least stay it till it comes back from the 4th then?
What I'm prepared to do today is, I'm prepared to dismiss those claims.
Okay.
Myself, just do a voluntary dismissal based on our agreement that I
The
filed.
specific performance claims,
The
okay.
specific performance claims, and also there's a Coggins report claim. So that cleans it up. That should allow them to proceed forthwith
On the appeal?
on the appeal.
Okay.
And, you know, another reason why I'm objecting to stay is my client's being sued by Mr. Miller in front of Judge Kaiser for not aggressively enforcing our documents, okay? So I am aggressively enforcing our documents.
Okay.
In this case, I guess anybody who has an injunction entered against them can always argue, well, let's stay it until the appellate court rules. Well, they've got to make a better case than just simply say, wouldn't it be nice? And there's a lot of non-monetary things that they really need to be doing.
Okay.
And you know, they've already gotten a reprieve for so many years, we're just trying to continue to move the case along.
All right, thank you. Mr. Tickton, the phone, please.
Yes, okay, so the fact is, we've had these years, there's not, all of a sudden now there's a rush where it would cause irreparable harm to our clients in the event they're successful. First of all, there is a meritorious case here, and I think Your Honor knows, you
Yeah,
know.
this is a close call. I understand, absolutely.
And so I don't think there's any question that there is a very good appeal here.
Okay. And so we posted the bond now, so but what about the non-monetary issues on the injunction? How do we
That-
address those issues?
Well, that's the point. It would cause irreparable harm
Okay.
for us to have to rebuild the house
Okay.
and do all of these things when in fact, and we're prepared to move this case as quickly as we can, you know, in terms of the appeal. It takes time. You know, we can't help that, but this is an honest effort. This isn't just to cause delay.
Because that's my only question. I mean, if I make them proceed on the non-monetary issues, does that not essentially make the whole thing moot at that point?
No, where it becomes a monetary issue is when he actually has to write a check
Okay.
and either spend money reducing the size of his barn or
Okay.
increasing the size of his house. It doesn't mean he shouldn't have to still comply with Your Honor's injunction that says no advertising, has to use the same vendors for all
Okay,
the
maybe
people.
that might-
But also submit his plans to the ARB. I'd like to see what he's supposed to be doing. Do everything maybe short of building. In fact, under your order, he has like 150 days to start building, so
Okay.
he's got plenty of things he can do
Because
over the
that's the
next
only
several
thing,
months.
I certainly don't want to have him expend any money with building anything, but what about the advertising? Is there certain things that he could do in light of, that would be, I'm happy to enter the stay, but would he stipulate that he would agree to those elements at that point?
Well, the advertising is one of the issues on appeal,
Okay.
and also in terms of providing the plans, that's going to cost them thousands of dollars to get the plans together
Okay.
to do this. Look, this is our last chance.
Okay.
You know, if we don't succeed on this appeal, then fine. They win, they get their attorney's fees, they get everything else. But why should we generate all of that extra work at this point and expense? I mean, really, has the advertising actually even caused them any harm whatsoever in all of this? It's not as though they're suffering any kind of loss because of any of this. You know, but we would suffer a great loss in the event that we now have to comply with the non-monetary.
This is a case where there was a settlement agreement 5 years ago. They agreed to all these things. Your Honor entered an injunction
I know.
ordering them to comply. They've gotten a reprieve all this time. Our position is we need to proceed with our fee and cost plan. They need to not advertise, as the injunction says. They're supposed to use the same vendors, supposed to submit plans to the ARB, do everything short of actually building the house.
Let me do this, and since I've already given them 150 days, I'm going to go ahead and grant the stay for 90 days, and let's see if you can file a motion to expedite the appeal with the 4th DCA. And maybe that's a way to do that. And then we can come back on a status conference after that, and you can keep me apprised of what's going on. So I will grant the stay for 90 days at this point in time. We'll hear your fee hearing in the meantime, so that won't be delayed in any day. So I'm going to grant the motion to stay for 90 days, and then at that point in time, hopefully the 4th will understand the need to expedite it, and then we'll see where we are after that. So the motion to stay is granted.
Thank you.
Okay, all right, thank you guys. Have a great day, everyone. Okay, let me go ahead and do American Express National Bank versus Johnson, please. Council ready? Yes. Good morning. Is the other side by telephone? Is that correct? Okay, let me give him a call. So it's 321-972. Okay, got it. Oh, you're here? Oh, so I don't need to call you? Oh, are you opposing counsel?
They instructed me to show.
Okay, that's fine. I was calling someone, not a problem. Okay, this is the hearing on American Express Bank versus Johnson. It's a motion to withdraw. Is there any opposition? No. Okay, motion to withdraw is granted.
Okay, the only opposition that I do have, in which I spoke with my rep in regards to the situation, was a document that was sent over to me.
Who do you represent?
I represent American Express.
Who do you represent?
In LLG, I was informed to come here. I'm Johnson.
Oh, okay.
I was instructed to come here.
Oh, okay.
Yes. Yes.
You did. Okay, that's fine. Okay, now I was
Sorry for the confusion.
I was
I
confused. Okay, that's fine then. That's fine. So I'm going to go ahead and grant it then, if that's okay then.
Okay, I was okay with the motion to withdraw. Yeah, it was just what I stated to her was the number 2, what she put on the documentation in terms of me not being cooperative, or I just kind of wanted her to kind of restate that in other words, so it doesn't reflect me as being a bad individual. Yes.
No. No one thinks that. No one is accusing you of being a bad individual. No one believes that at that point in time.
Right.
I'm going to grant the attorney's motion to withdraw, and then you can hire a new attorney then.
Okay.
Thank you so much. Do you have any questions?
No, that's all. Thank you.
Okay, thank you. Have a great day.
In your honor, so
Yes.
will opposing counsel submit a proposed order?
No, let's do that right now, just to be on the safe side.
I know the
Oh,
opposite.
okay, that's
I don't know what
fine.
other-
Yeah, just go ahead and can you have your attorney just submit an order?
Yes.
Okay, perfect. Thank you so much.
Sorry, the other thing is there's a case management conference that's scheduled for next week.
That's canceled. CMC's canceled for next week. Great. Thank you so much, Your Honor. Let me go ahead and do Molitor versus Universal Property and Casualty, please. Motion for attorney's fees. Counsel ready? Do we have a court reporter? No? Okay. All right, good morning, everyone. This is Molitor versus Universal Property. This is plaintiff's motion for attorney's fees and costs due to confession, judgment, and I read the motion. Anything to add to the motion at this time, counsel?
The only thing I'll add, Your Honor, is that counsel states in his response to the motion that courts generally do not apply confession of judgment where the insured is not forced to sue to receive benefits. However, they have asserted no affirmative defenses with regards to an untimely lawsuit or a frivolous lawsuit.
Okay.
So I believe that payment 6 weeks post-service of process constitutes confession of judgment, thereby entitled to fees.
Let me hear a response, please.
Yes, Your Honor. The payment was actually made to an AOB company. They're actually a third-party company, and they're not made to the insured. They were made to mindmoldertest.com. They were made for remediation services, and actually the defendant has not asserted payment as a defense.
Okay.
It's not asserting that it's ever paid.
So you're saying it's not a valid confession of judgment then? Okay, then. Yeah, I can't treat it as, it's not.
There is no AOB, Your Honor.
Oh.
It's to a mold testing company for which my client was specifically responsible because there was no direction to pay. There was no assignment of benefits. There's a check made payable to both plaintiffs.
But they're saying it's not a confession of judgment, that's the thing.
I understand they're saying that, Your Honor, but they made a payment to my client for damages that he was responsible for. There's no assignment of benefits. There's no direction to pay.
But I can't make a legal determination. How do I make a legal determination that that's a confession of judgment then?
Because there's a check made payable to Thomas Molitor and Jennifer Molitor posted.
But they're claiming what the basis is. They're saying it wasn't in terms of settling the case then. So the motion's denied.
I understand it's not in terms of settling the case, Your Honor, but it was a post-suit payment.
But they're
And
saying it's not, I can't make that legal determination. That's what they're saying if the defendant's not agreeing to that. So the motion's denied. Thank you guys. Have a great day. Let me go and do Nation Star Mortgage versus Manuel, please. Motion to continue. Counsel ready? Nation Star versus Manuel. This is plaintiff's motion to continue and strike the order of the non-jury trial. And I read your motion. Is there any opposition?
No, Your Honor. It's Lincoln's motion. Mr. Kelly is in another courtroom with Judge Gilly, and it's unopposed.
Okay, I'm going to go ahead and grant it then. Thank you
Your
so much.
Honor.
Have a great day. All right, let me go ahead and do Gay versus Tower Hill, please. Council ready? What's this here? All right, good morning. You have a court order? No? Okay. All right, good morning, everyone. This is Gay and Wetzel versus Tower Hill. This is defendant's motion to determine reasonable fees for plaintiff's expert. And I read your motion. You may proceed when you're ready, counsel.
Good morning, Your Honor. My name is Gene Fernandez on behalf of the defendant. Well, as you know, this lawsuit is based off of homeowner's insurance claim. The defense counsel is trying to depose the plaintiff's general contractor.
Okay.
And he has a fee of $350 hourly rate, 2.5 hour minimum, plus $125 for.
Why do you think that that's excessive? Is that not a reasonable hourly rate, $350 an hour?
Usually we have orders, I have an order here from on a previous motion was heard, and it was around $200. I was informed by plaintiff's counsel earlier today that this person that prepared this estimate is an engineer, so I understand that the rate could be a little higher.
Yeah.
But I still think that the minimum 2.5 hours is still, it should be stricken. We don't know how long the deposition is going to be.
Why don't you do this? Let's just do an hour, and then if it goes longer than that, just bring a check for more than that, if that works. But the hourly rate is reasonable for $350.
Thank you, Judge. And one more thing, Your Honor.
Sure.
The plaintiff's contractor wants that payment before the deposition. Can we agree that we'll pay him after the deposition?
We'll pay for 1 hour before and the other after the deposition, then, depending on, because that's fair. So let's see how long the deposition's going to go.
Thank you.
All right, thank you, guys. Have a great day, then. All right, let me go ahead and please do Ford versus SCG Atlas Wellington. Council ready? All right, good morning, everyone. Do you have a court order? No? Okay.
No, we don't, Your Honor.
All right, good morning, guys. Nice to see you both. This is Ford versus SCG Atlas Wellington. And this is plaintiff's motion to strike defendant's second affirmative defense. And I read your motion, and you may proceed when you're ready. And this is regarding fault and the fabric. Is that correct?
Correct, Your Honor.
Okay, you
And
may
it's
proceed.
actually just a portion of the affirmative defense. I'm perfectly okay, and I've attached a copy of the answer in affirmative defenses for Your Honor. I highlighted the section, that issue. It's really the last section, last 3 lines in the second affirmative defense where he just says any and all potential non-parties that may be identified in discovery. My biggest concern, just a little background, this is a wrongful death case where a man was shot to death. And our statute, obviously, in a wrongful death case is 2 years. It's going to run in November of this year.
Okay.
So if they don't identify someone by that time, then that would be severely prejudiced.
Okay, all right.
So that's my concern.
Let me hear a response, please.
Your Honor, and I completely understand. The reason we put that in is, as you know, probably to preserve our rights, because we're required to plead it affirmatively at the initial pleading.
I know, but you can always amend it. It's not fair under February. You do need to name them. So I'm going to go
Yes,
ahead
Your
and
Honor.
grant the motion to strike. You could, if you find out who it is, you can always go ahead and name them. And we do need to be concerned about the statute of limitations issue.
Okay, Your Honor, so just striking that.
Just that portion. So the motion to strike is granted.
Thank you so
Thank
much,
you, guys.
Your
Have a
Honor.
great day, everyone.
Do we need to submit an order?
Yeah, just that'll be great. Thank you so
Okay.
much. CIT Bank versus Dawn White LeConte, please. Council ready on that one? All right, good morning.
Good morning, Your Honor.
Morning.
Pete Goldbaum on behalf of Dawn White LeConte.
Yes.
Opposing counsel stepped out. He said he'd be back in 11.
Okay, we can wait a few minutes. That's not a problem.
Thank you.
Okay, let me please do Armand versus, is it Borden Arada, please?
Yes, Your Honor. Plaintiff's counsel stepped out for a moment.
Okay, no problem. Let me please do SSI Lubricants versus Osher Oil Company.
I'm here for that one, Your Honor.
Good morning, Your Honor.
Good morning.
Jeff Garber for the plaintiff.
Yes.
Good morning, Your Honor. Ted Blylock for the defendants, Osher Oil and Lewis Coast.
Good morning, nice to see you both. We're here on plaintiff's motion for the order of a show cause pursuant to 3.840 and then also for imposition of the civil contempt sanction. And Mr. Garber, I read both motions. You may proceed when you're ready.
Your Honor, this is going to be a quick one. Mr. Blylock and I were able to reach an agreement. May I approach, Your Honor?
Sure, of course, absolutely. Let me take a look. Okay, that seems very reasonable. I'll go ahead and sign an email out then. Thank you, guys. Have a wonderful day.
You too, Your Honor.
Thank you, guys. Okay, let me go ahead and please do, is it Bob and Ryan versus Home Depot?
Perfect, Your Honor. Yes, Your Honor. You're absolutely correct. Good morning.
Just want to make sure I'm pronouncing it correctly.
Yes, Your Honor.
All right.
You are.
Yes, ma'am.
Good morning. We're here in Bob and Ryan versus Home Depot. Could counsel please read your appearances for the record?
Gary Sasser on behalf of the plaintiff, Your Honor.
And Andrew Silvershine on behalf of the defendants. Good morning, Your Honor.
Good morning, everyone. We have
We've used our time judiciously and civilly to discuss things. I'll let Mr. so we're trying to discuss what we've agreed to and
Excellent.
what we dispute.
Which ones were agreed to?
So there were actually a couple motions set forth
I
today.
think we discovered objections, yeah.
Exactly. The discovery objections we will go through. The motion to compel discovery has been figured out. The defendant's motion to compel discovery. And the plaintiff's motion to exceed 30 interrogatories has been agreed to, and we'll figure that out as well.
Excellent.
So we can move on to the discovery issues.
So we have surveillance interrogatories and request for production, is that right?
Correct.
Okay, all right, so which ones remain outstanding?
So we can start with the interrogatories. It looks like 1C.
Okay, that's fine. What about 1B was worked out?
1B, we've agreed to, we've provided the names. I told Mr. Sasser outside we will provide an additional name. We provided the mailing and street addresses already. The phone numbers that he's requesting, I'm a little wary of providing a third-party cell phone number.
You could do so pursuant to confidentiality agreement, is that okay?
I would feel more comfortable doing that. Just
Yeah, let's confidentiality agreement then. All right, so let's do 1C, 1D, 1E, 1F, and 1G.
All right, 1C, a description of the equipment used to perform the surveillance. I don't see how this is relevant.
Well,
the issues
I mean,
in this
if there might
case.
be issues with the surveillance equipment, whether it captured everything, I'm going to overrule that objection. All right,
In
let's
terms
do,
of, and what exactly, the make, the model, the serial number of the cameras that are used, what exactly?
I mean, does it capture things? Does it capture the angle? I would assume that's probably what it's.
Again, this is a Home Depot handheld camera versus an iSpy, high-tech piece of equipment is what we're looking at.
Yeah, so that's overruled. Let's do 1D.
Internet surveillance is what we're seeking, is what they've done with internet. Big issue, as the court well knows from its well-written opinions.
Okay, so that's overruled.
This is fine, this is fine.
That's fine. Okay, so 1E.
And again, I told Mr. Sasser, we'll go ahead, we'll describe whatever surveillance activities have been done. So 1E is fine.
1F and 1G remain.
Description of
Basically contracts, billings, and things such as that.
Yeah, I mean, is there any
notes,
basis
and
for
it was really just he's asking for notes and diagrams.
Does Home Depot have that information?
To my knowledge, we don't possess any notes.
Then it's easy, then it's none. Okay,
That's fine.
and no diagrams either?
And to my knowledge, no
Okay, that's fine.
diagrams.
So let's do the objections to the request for production. 1, 5, and 1 and 5, I guess.
Yeah, there are a couple. There are a few. Number one, clothing and uniforms that individuals wore while performing surveillance. I mean, we've had surveillance done over 4 years ago, over 3 years ago, to ask for the clothing that was worn.
At the time, but you'll catch it on the video, right?
Your Honor, they have 3 different firms.
Okay.
18 different days.
Okay.
There's a variety of
Okay.
things that can be done. We want to know if they're carrying firearms, how they approached, how they did this. And it's, from the video that we've got, we don't know, we could see what was there, but what else was done during those 18 days?
Okay.
And not captured on video. This is what we're after, and how they were attired, whether or not they're carrying firearms,
Okay.
why they were, then, it gets into depositions, why they carried guns in the first place.
Okay, all right.
Judge, how is that relevant to
Yeah, our guns-
slip and fall in
guns-
this case? What clothing he was wearing? I just don't see the
Guns material
relevance.
in any way? That they were having guns? Does that material in any way do slip?
Your Honor, we'd go to the fact, why are you carrying a gun doing surveillance? Is my client posing a threat such as that? We want to know exactly what impeachment they have. It's another item that's in here.
Okay,
What impeachment they have,
I'm gonna
but-
sustain that objection. I don't understand the basis for that. Let's do
And
that.
Judge, let me just be clear. We provided all surveillance video
Okay, good.
to the plaintiff, and he can see what was done in this case.
Wonderful. What's next?
So 5 is next.
Okay.
It's asking to produce the original camera, the video camera, iPhone, so it's asking a private person.
Just a description.
Just a description of it. That's all, not the original camera.
Well, this is a request for production,
Okay,
so
so
it's
you-
asking us to produce it.
You don't have to produce. You don't have to produce it. Just a list of what it is, or just maybe a picture of what it is. How's that? Is that what you need, Mr. Sasser? Just a picture?
Correct.
Okay, just a
And
picture of the
again, Your
camera.
Honor, these are items that are not in our possession, custody.
Then you don't need to
control.
produce them. Then that's easy.
Okay.
Number 7.
Number 6 we agreed to, so that's been taken out.
Number 7.
Number 7 is, we need to kind of narrow down what he's asking for here.
Okay.
And
What's number 7?
We want to know what the defense firm has in their possession regarding the people they've hired. Okay? And, this is probably not the first time they've been hired. There's probably a long history between defense counsel and these three investigating
Do you have
firms.
contracts with these companies?
Specifically for each assignment, I mean, for this assignment, I'm sure, but to go back and look at, other clients that the firm has used, it's not relevant to this.
No, you don't have to disclose other clients, but do you have contracts with these companies?
For this
Yeah,
specific
do this one,
job?
yeah.
Okay, that's fine.
All right, let's
That's
do
why
this
he's asking for, any file and document of any
just this
nature.
job.
Okay.
Yeah, it's more detailed on number 9 because they ask for billing records, timesheets, memos, reports, notes taken, logs of work performed. We're looking for anything other than they're claiming a privilege, of course, on their incident of their reporting, which we understand is the claim of privilege, but everything else pertaining to what's going into the report, if they're keeping logs, time logs,
Whatever
activity
you have, go
logs.
ahead and produce that then.
So the work file.
Yes, everything that's other than that's privileged.
Okay, and the same thing for number 10, the communications between Home Depot and the attorneys and the
Yeah,
investigators.
please don't produce any privileged information, but the other
That's
information.
what I just want to make sure.
Yeah, no privileged information.
And that includes any attorney mental impressions.
Yes, all right.
The number 11 is basically.
Sorry, Gary, sorry. Number 8, we skipped 8. Are we good on 8? We agreed to take 8 out?
We took a,
Okay.
All right, next.
You are correct. The number 11, it goes into what websites, we want to know what, again, with description now, what websites you were using and how you conduct internet surveillance.
That's fine, that's
And we've
overruled.
agreed, we can describe that
Okay.
in the interrogatories.
Excellent.
13 and 14, again, are repetitive, just overkill on my part.
Okay.
Time records, time sheets,
Oh, we've already
activity
covered that.
logs, bills.
Okay, we've already covered
And what about number
Checks.
12, Gary? Number 12, I have he's asking for the vehicle that was used and driven by the surveillance.
Just give us the name of the vehicle. You don't have to obviously produce the vehicle,
That's
so.
correct, just a photograph. That's
Yeah, just a photograph of the vehicle.
vehicles they use.
And again, Your Honor, that's something that my client doesn't have.
Then you don't need to produce, it has to be within your possession, custody, control.
Thank you.
The 16 was the catch-all, basically a surveillance file that they have, and they did have a privilege log as to the report. I understand that. We're not fighting the privilege log today, Your Honor, but everything else that's in the file, again, a catch-all.
And just to be clear, Your Honor, in terms of the entire file, we'll produce what's in our possession.
Possession, custody, control. You don't need to produce anything else.
Right. And it goes, and 18 is a little bit more detailed with rules and regulations, standards, that they have instructions as to what to do. I've seen instructions like, I want you there on Christmas Day, so you come to
Again, that would be communication, so that would be covered by the other request. What else is left?
the restrictions. Number 20, headed to trial. What impeachment evidence you got on our client?
Okay, that is.
Objection. Like, whoops.
And we've we've obviously filed our exhibit list. They're all listed there. I told Mr. Sasser anything he wants a copy of, we're happy to provide.
Perfect. All right, let's do 21.
21, I believe, is this.
Again, for impeachment, I want a
Same
description of what documents they're going to use for impeachment.
Okay,
And what they have.
Just reference what's on your exhibit list.
Sure, that's fine.
All right, thank you guys.
Thank you, Judge. I appreciate it.
May we be excused.
Yep, wonderful. Have a great day, guys.
You too.
Thank you all so much.
We'll submit an order.
Wonderful, thank you guys. All right, let me go ahead and do Solonic versus Harvest Seasonal Grill, please. This is a case management conference, Council ready? All right, good morning. This is a case management conference. And what is the procedural status of the case?
Good morning, Your Honor. Actually, plaintiff's counsel appearing by phone.
Sure, what's the phone number?
813-842.
842
7071.
7071. Okay, let me get the call.
This is Jay Lechner.
Oh, good morning. This is Judge Sasser. I'm calling you in Solonic versus Harvest Seasonal. Are you ready for the case management conference?
Yes, ma'am.
Wonderful. What's the procedural status of the case, guys?
Well, we're in the discovery phase right now. We exchanged, this is Jay Lechner on behalf of the plaintiff. We've exchanged written discovery. We have been in the process of setting depositions, but we've also been engaging in settlement negotiations.
Okay, great. All right, so I'll do another status conference in 90 days then. Wonderful. I hope you guys get the case settled.
All right, thank you, Your
Thank
Honor.
you guys. Have a great day.
I've got a blank order.
Yeah, just put that in order. 90-day case management conference. All right, let me do the other case management conference. Scott versus Tickton Law Group. You guys ready? Come on up. All right, good morning.
Good
Good
morning,
to see you
Your Honor.
again, all right?
Good morning, Your Honor.
Good morning. All right, this is Scott versus Ticton Law Group. And what's the procedural status of this case, guys?
Well, we have one motion
Oh,
for
okay.
summary judgment
Oh, perfect.
that's
Okay.
pending, and it needs to be set down, or I was hoping Mrs. Scott would be here
Mrs.
today.
Scott's not here. So, Mrs. Scott's not here, so guess what? Case dismissed. Have a great day.
Thank you. Thank you.
Dismissed with prejudice. Thank you. And we'll send that order to you by email today.
Thank you.
Thank you, guys. CIT Bank versus unknown successor trustee. Are both sides here? CIT. Have a great day, everyone.
Thank you.
Thank you. CIT.
Is that McCown?
Yeah, we're waiting. We're on the
Yes.
opposing counsel. Both sides here. Come on up.
Yes, Your Honor.
All right. Good morning. This is CIT Bank versus unknown successor. This is plaintiff's motion for default, and I read your motion. You may proceed. Right? This is yours.
Yes.
Okay. Yes.
Oh, I'm sorry, Judge. This is our motion for default as Sir Frederick Lee Solomon.
Yeah.
Mr. Solomon was served served by constructive service on April 6, 2018. As of today, nothing has been filed in the court file. We put him on notice of today's hearing in hopes that he would file something, so we asked him to default. Thank you, Your Honor. I have orders and all.
Okay. All right. Now let me do Bank of New York Mellon versus New Ray LLC. Motion for leave to amend. Anyone here on that one?
Yes, Your Honor.
That's yours as well. Okay. Got it.
I have two motions in this one. There's a motion to appoint a guardian ad litem for Clara Brew Dara. I can barely say my own name. Brew Derrick.
Okay.
And then, as well as our motion to file for leave to file an amended complaint, adding the minor Danielle Milagros Arboko.
Okay.
And I have orders for both of them.
Yeah, I'm going to grant both motions. I'm going to grant the motion for leave to amend, and I'm going to grant the GAL as well.
Thank you, Your
All
Honor.
right. Let me do. Is this also your CIT Bank versus LeConte?
Yes, ma'am.
Oh, let me do that one.
You're good, ma'am. Those are orders for these two. Judge, in this one, my client had told me, Mr.
Motion canceled, right? Sale.
Yes.
Okay.
Counsel and I had the opportunity to speak outside. He told me this was the first cancellation. My client had instructed me to oppose.
Okay.
However, he told me about the issues that he's been having with his client trying to get hold of the bank because of her deceased husband.
I think that's valid. I think that's a legitimate reason. So let me go ahead and cancel. I'm happy to reset maybe 120 days. Would that be enough time, you think?
I mean, hopefully we'll be able to have access to communicate with the bank. That's the real trick. And
I know,
then
it
that
sounds
would
like
be
they're
part
having
of
some
it.
difficulty.
And Judge, I was going to suggest maybe if you would also order a conciliation conference within 10
Maybe
days.
see if you can get the case settled then and get that would be even better then. So let me do that then. So motion to sale is canceled, conciliation conference within 10 days, reset the sale date 120 days. So hopefully we can get this case resolved and the house saved then.
Thank you, Your Honor.
Thank you guys. Have a great day.
You too, Your Honor.
All right. Let me go ahead and do, is it Armand versus Bernardo? That's already on that one. Armand Bernardo.
Good morning, Your Honor.
Guys, all right, this is,
On behalf of the plaintiff.
this is your motion for leave to amend answer and affirmative defenses, defendant's motion, and I read your motion. You may proceed when you're ready.
Yes, Your Honor. This is Jared Lindsay on behalf of the defendant. This is our motion for leave to amend to add the res judicata and collateral estoppel issues as affirmative defenses. We had originally raised in a motion to dismiss.
I saw that,
We
yeah.
spoke, we brought it in front of the court and determined.
I think it's
that
legitimate,
that's what
so
was
is there any
to-
opposition?
Yeah, Your Honor, I did file an answer in opposition and I forwarded it to Your Honor's attention.
No, I did, but wait, amendments are liberally granted.
Okay, there is an, we oppose, and I'm going to tell you why, Your Honor. First, the complaint was filed and they proceeded with discovery, everything, they even set a deposition date for my client, notice of proposal for settlement. Then all of a sudden, 2 months later, they filed a motion to dismiss and a motion for summary judgment based on res judicata. And it was set for hearing, we were hearing from Your Honor, and it was denied, and the reason it was denied is because they didn't plead it in their incident affirmative.
But now they're pleading it.
And now they're seeking leave to amend it to add it. However, Your Honor, and I understand if you want to allow it, however, it would be kind of a waste of the court's time and kind of prejudicial to my client because he wasn't part of the prior lawsuit.
But then we can make a determination on a motion to dismiss. Motion for leave to amend is granted. All right, thank you guys.
We have blank order on the back of the
I'm
package.
demon file that's in today's date.
Thank you. May I get the package? I already said a blank order on there.
All right, anybody else here for UMC or CMC? Nope, nobody else here for UMC or CMC? All right, let me see if let's see, go ahead and see. On the 9:30, are both sides here? Come on up. Just one side? Okay. Oh, both sides? Come on up on the 9:30 then. All right, are you the court reporter on the 9:30? Oh, 9:30, okay, go ahead. We do have the court reporter ready on the 9:30.
Good morning, Judge. Do you, Neil saying we have to plaintiff, do you have courtesy copies of?
I do, I have all the materials, yeah.
Not sure, it's not. Court reporter ready?
As soon as she's ready, we'll get started. All right. You ready? Do you need a few moments?
Yeah. Thank you, yes. I am.
Okay, she's ready. All right, good morning, everyone. We're here in Patino versus Town Center Mall at Boca Raton. Could counsel please state their appearances for the record?
Neil saying on behalf of the plaintiff, Louisa Patino. Robert Goodrich, Your Honor, on behalf of Town Center Mall.
Wonderful. Nice to see you both. We're here on the plaintiff's MSJ on non-delegable duty. I had an opportunity to read the entirety of the motion and everything that was filed by plaintiff's counsel, and you may proceed when you're ready, counsel.
Yes, Your Honor. Thank you very much. May it please the court, Your Honor. We're here on plaintiff's partial motion for summary judgment on the issue of liability and the second issue of a non-delegable duty on behalf of the defendant, Town Center Mall. Now, respectfully, Your Honor, I'm well aware that summary judgment is sparingly granted on issues of negligence, but that's not an insurmountable hurdle when the evidence is proper in a particular case. And I'm not asking you to find summary judgment, I'm simply asking for partial summary judgment. It's just a little clear. So, the main issue, as laid out in the motion, the first particular point heading is that Louisa Patino is submitting to the court that based on the deposition testimony of the corporate representative of Town Center, Salvador Salganada, the corporate representative testified in this case, based on his testimony that there's a hazardous condition and that the condition itself posed a danger to the business invitee, that there has to be some finding of negligence on behalf of the defendant, Town Center Mall, based on the controlling case of Jane Izquierdo versus Gyroscope.
Okay.
That's a 4TCA case, Your Honor. And I say this respectfully, Jane Izquierdo, that was my case. I was the defense attorney on that case. Went to trial, straight defense verdict, then the case went up to the 4TCA. 4TCA reversed me on that case, Your Honor, and taught me a lesson. So I'm using that case in the converse now,
sure,
on the plaintiff side. The second point heading in the motion is that essentially what we have here is a non-delegable duty on the part of Town Center Mall with respect to maintenance, control, and operation of their premises in a reasonably safe condition to the business invitee.
Okay.
A responsibility, a duty that cannot be shifted to a co-defendant in the case, a tenant in the case. So those are essentially the two particular point headings, just to lay out the lay of the land.
No, I read both.
Okay.
Let me ask, I'm going to certainly, and I read the entire motion. Let me ask Mr. Goodrich, the response as to the negligence issue on the case law. So generally there are issues, but these are, it's a motion for summary judgment. All material inferences have to be against the moving party. Let me ask you on the negligence issue.
Now, on the negligence issue, Your Honor, if you review the testimony of Saldana, who was the mall manager, it didn't say we were negligent. It said we wouldn't do it the same way.
Okay.
And, you know, it did not say that it was a hazard. It said it could be a hazard depending upon placement. The issue of, now, the question for the mall, and this is the distinction, because this is a tenant space where this occurred in, and a leasehold space. The case law, there is no case law that I've ever located that said that if the mall leases to Gymboree or leases to...
That it bears liability.
Yeah, that there's liability for them inside their leasehold interest because they don't have the ability to control.
And there's no control. That's the
There's
issue.
no control, and that's the issue here. The mall said, now the case law does make that distinction, and there are cases that say if you are aware and see a hazard, like if I see something that a Bird Eyes or Macy's employee is doing that's hazardous, you then would have an obligation to step in because you're the owner, and you might have some ability to control the area. But there isn't one that says that if you're not aware of the condition, that you would then have that ability. Now, I think the argument here is that there's a confusion between the non-delegable duty. Non-delegable duty started with the concept of contractors.
Sure.
Can you delegate the responsibility to a contractor? Because generally you don't. And the case law, when you get into the actual case law, non-delegable duty, the concept came up because they said there are certain ultra-hazardous activities, as a matter of common law, that you can't delegate away. But the issue here is we have a tenant space that is a lease, we have a leasehold, there's no testimony. If the mall had said, yes, we saw it, oh God, this was negligent, I can't believe that it was done, and we walked away from it, different case completely, but that's not what was the testimony.
Can we have a vote, please?
Yes, Your Honor. So we're not proceeding under a transitory foreign substance here.
But how would the mall owner have any knowledge of this issue specifically when they have no control over the individual space?
That's the problem with the defense's reply motion here, Your Honor. And if I may, and this is the critical issue that I would like the court to focus on.
And I'd like you to point out any case law, anywhere in Florida jurisprudence, that holds a landowner responsible in this situation, because I'm not aware of any.
Well, specifically, Your Honor, what we have here is improper evidence that's submitted by the defense counsel. The lease agreement, Your Honor, is not supported by an affidavit. It is not even record evidence.
It's your
in this
burden,
case.
not his. I mean, it's not established. It's an undisputed fact that the mall owner is separate, as a separate entity than the store.
Your Honor, the testimony in this case from Mr. Salvanana, and what's undisputed in this case, that the outlet itself, the metal outlet, is a permanent fixture of the mall. And the mall retained possession, control, and maintenance.
So you're saying the mall is responsible for every single time there's a fixture and a tenant, that they would have no responsibility to know that there's something wrong with a wall outlet? I find that hard to believe. There's no case law. How would any responsible, anybody know if they have no daily control over the individual space?
Well, Judge, essentially what we have here, we have the testimony of Mr. Salvanana where he agrees that this is a hazardous condition. He admits that.
He says it could be, according to Mr. Goodrich.
He does testify specifically, Your Honor, if I could point Your Honor to the specific line item testimony, where he states on page 22, lines 1 through 26, question, could be a dangerous hazard depending on how they're using it? Answer, again, I would tell you that cords, we would not install a cord like that. That is definitely something that the tenant had installed. Answer, and we would rely on them, expect them to maintain and install anything for their kiosks to be safe to the shopper and safe to the employees. Also following up on the question, the cord, our contention is that the cord was exposed here and my client tripped off the cord. Assuming that is correct, would you agree that that is a trip hazard condition? Answer, I would expect the tenant to cover that up to prevent that kind of incident. Question, okay, and how would you expect them to cover that up? Answer, number one, it's part of their lease that they have to maintain a secure environment. That is common sense. And question, do you have them put like warning signs over the cords? Answer, the tenant installed this incorrectly completely. And it's just, the kiosk should have been over there. I mean, just a few feet.
Where's the control issue?
The control issue, Your Honor, is that the fact that there's an admission by the corporate representative of Town Center that this is a permanent fixture of Town Center Mall. That's undisputed, that this is the permanent fixture, that the outlet itself is supplying electricity to the kiosk. Since that's a permanent fixture, they maintain possession and control over that fixture.
Do you have any case law in this situation, analogous case law?
Judge, what I'm relying on is the case that's cited in the papers.
Okay.
It's U.S. Security Services versus Ramada. It's a third DCA case. Do you have a copy of that?
I do. I've read everything, counsel.
Okay, but in essence, Judge, when you establish that, first off, you establish the basic duty that the landowner has this duty of care to the business invitee to maintain the premises in a reasonably safe condition. Once that business duty is established, that non-delegable duty is established, the business owner, Town Center in this case, cannot delegate that to an independent contractor. They cannot contract that away to an independent contractor.
But they don't have control over the store or the fixture. That's the issue.
Well,
and
Judge,
you have to establish the control. It's not defendant's obligation. It's
I
your burden.
have, Judge, I have carried that burden. I've carried that burden by establishing undisputedly from the testimony of Mr. Salvanata that essentially they're responsible for the fixture, that there's a permanent fixture, they're responsible for it. It's not something that's delegated away, contracted away to the
Motion's
tenant.
denied. All right.
Thank you, Judge.
Thank you, guys. Have a great day. All right. Let me know Deputy, you want to see if the other side's here on that 8:30 that went away? Otherwise, I'll do the 10 o'clock. All right. Thank you. That's Oxidine versus Ramirez. Thank you, guys.
Judge, I have a blank order.
Yeah, just put 9. That's fine. Thank you, guys. Have a great